I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. AI, employment, bias, and the EEOC. Those are the topics for today's episode. There is a lot of enthusiasm and optimism for the ability of AI to transform the hiring process. Everyone who goes through a traditional resume and interview hiring process probably asks themselves at some point, isn't there a better way to match talent and skill with need and opportunity? AI may end up helping that, but you can't really use the words AI and employment in the same sentence without some observers flagging the risk of bias. Don't get me wrong, those risks are real. AI has the potential of replicating bias at scale with widespread and undetected impact. It's a real challenge for the future of HR. And so I'm excited to be joined on today's episode by Commissioner Keith Sonderling of the United States Equal Employment Commission. Commissioner Sonderling was confirmed by the U.S. Senate in 2020 to serve on the EEOC and act as vice chair of the commission. He's also one of the leading voices in the U.S. government regarding the interaction of AI, bias, and employment, and both how developers and users of AI can seek to balance the opportunities of AI in HR while managing bias risks. Commissioner Sonderling, welcome to the podcast.
Thanks for having me.
So excited that you're joining. I've been a long admirer of yours as I've heard you speak passionately in a really articulate way around how AI is impacting the areas of employment law and where you see the EEOC having an important role in that. And maybe let's just start there, because I think many of our members of our audience are not familiar with the EEOC. Can you describe kind of your role as a commissioner and importantly, where the EEOC is leaning into artificial intelligence issues?
Yeah, well, I appreciate it. It's great to be with you here today. You and I have done a panel together, and I've been able to learn from you as well. So I'm glad we're having this conversation. So I'm Commissioner of the United States Equal Employment Opportunity Commission. There's a lot of federal agencies in DC. We're unique. We are our own agency, and we are responsible for enforcing all workplace anti-discrimination laws and promoting equal employment opportunity in the workplace. So when you think about it, we are the regulator of human resources. So everything related to hiring, firing, wages, training, benefits, and just really everything related to your employment, that is our mission. So when you think about the big ticket items that you often hear in the news about human resources, such as diversity, equity, inclusion, the Me Too movement, any type of discriminations, accommodations, and that's our agency. Our agency is very special in that it was founded from the civil rights movement in the 1960s of Martin Luther King marching on Washington, D.C., led to the creation of the Civil Rights Act, which created this agency. So, we have an extremely important mission about civil rights protections in the workplace. And because we were one of the first countries and agencies related to civil rights in the workplace, a lot of countries around the world have followed our model as far as workplace protections, as ensuring people have the ability to enter and thrive in the workforce without being discriminated against related to those protected characteristics, again, like age, religion, disability. So, we are in a position here where at the EEOC also has something unique about it, where, for most employment claims, employees, applicants, former employees can't sue their employer directly in court. They have to come to us first. So we see almost every case of employment discrimination in the United States. So we're in a very good position to see what those trends are and what those issues are nationally.
Yeah, that's really helpful background. And I think it really kind of sets the context, because I think many folks are thinking about what it looks like for artificial intelligence to play a leading role in employment-related decision-making, including in connection with hiring and with firing and evaluations. And I know this is an issue that you're particularly passionate about. I'm interested in maybe why, because, when you were coming in to the commission, I think you made the decision to kind of lean into these issues and make it one of the focus points of your tenure there.
Because it's an issue we can't ignore. And, very much like other regulators and other people in this position, before I was in government, I was a labor and employment management side defense attorney. It's important for us to get ahead of the issues and see what those issues are. And especially here at the EEOC, a lot of what we do is driven by the news. So, you think about what we have to deal with. And when the Me Too movement happened, we have to put all our resources there. Then the women's soccer team with pay, we had to deal with pay equity, and then COVID, and then, some of the racial recognition in work post George Floyd. So there's always going to be a significant distraction of where we need to spend both of our compliance assistance resources and our enforcement and litigation resources. So when I got here, I wanted to say, well, what are the next trend for the workforce? And what is the next trend that we as an agency can proactively get ahead of to prevent something like the Me Too movement from occurring? And that's when I learned about artificial intelligence really for the first time. And like many others, I don't have a technical background. And, we'll get to how most agencies don't. The challenge related to this was, actually first understanding what it means in our space. And, like many, I thought this was actually about robots replacing human workers. And I didn't think that was going to be a big enough issue for us to tackle because, that's maybe manufacturing or logistics of actually replacing humans, not, the broad scope of employment that we cover. And then when I started diving into it, I realized it's much more vast than that. And that there's artificial intelligence out there related to every aspect of the employee-employer relationship. And there's AI out there, the examples in this space, just about everything you can imagine related to your employment. There's artificial intelligence software out there promising to do it better, more efficient, more economically. And in our space, really trying to eliminate one of the biggest issues that we've dealt with at the EEOC since we were created, which is bias, human bias. And, a lot of these products are being developed, deployed, and used to deal with bias and elimination of bias in employment decision-making, again, which is the reason my agency exists. In the last 2 years, we've collected, outside of technology, we've collected almost $1.2 billion from employers for violating these laws. So the problem is there. And a lot of these software have been developed to try to tackle that problem. So let me just get, for context, there's AI out there that will create job descriptions, that will create advertisements for these jobs, that will seek resumes, that will review the resumes, that will rank the resumes, that will select which resumes get interviewed. There's AI in the employment space that will actually completely conduct the interview, where your entire interview is done through a chat bot or, an AI bot. There's AI that will then judge you how you did on the resume based on on the interview based on a host of factors. And there's AI will determine if you get a job offer or not. There's AI that will determine what your compensation should be. Then there's AI once you're hired that will determine, based on your social profile and other metrics, where you should be within that organization. Maybe you applied for one job. We believe you'd actually be the best person for this job. And these are going to be your colleagues based upon what the algorithm determines. Then when you're there, there's AI that will completely be your boss and tell you what you need to do that day and give you your tasks, and then also do the performance management and grade you and do your performance review. And there's even AI out there that if you don't meet those expectations, they will tell you you're fired without any human intervention. So just about every type of decision HR professionals and employers do in the employment space, there's AI out there promising not only to do it more efficient, economically, and faster, but to eliminate bias. And that is where it gets to a very, very complex and complicated conversation.
Yeah, and lots of issues to dissect there around kind of where it is that we potentially see the perils and the uses of artificial intelligence. But one of the things that I've heard you talk about in the past is actually there's quite a few benefits, right, that we should not ignore. In fact, I don't, in all of the times that we've been talking in the past, I actually haven't seen you in some ways, regulators can be seen as anti-AI and throw in like all sorts of shade at kind of the technology. And I actually haven't seen you go in that direction. In fact, I think it's been like, hey, there's actually a lot of positives here that we need to harness while at the same time managing the risks. Interested in your perspective on where you see those big benefits coming from, especially kind of on the HR side, before we start talking about how to manage those risks.
Yeah, I think it's important to kind of cool everyone down in this sense where, there's a lot of people here in Washington, D.C. and state capitals and governments around the world that want to say this is the absolute worst thing out there. and it's going to cause a lot of harm. And then you have a lot of people in the tech space saying this is the best thing of all time. And I think, I've just taken a very balanced approach. And just like any other type of decision, there's a lot of factors that go into it. And I've been trying to at least flip the narrative at the outset, saying that, look, if this is properly designed and carefully used, which are two completely and separate and distinct, very important concepts, that AI can actually potentially do a better job than humans and eliminate bias. And we have to take a step back and just, go to some of the very basic, longstanding issues that we faced at the EEOC. A male and female apply for a job. The male resume is more likely to get selected, even if the characteristics, the qualifications are identical. There's studies out there that Asian Americans and African Americans who whiten their resume by deleting any references to their race that may be indicative of the race are more likely to get selected if they remove those than having those on there. You think about some of the other issues, think about walking into an interview. When you walk into an interview, or now everything's on Zoom, what is the first thing that interviewer sees? They see you, and they see basically everything that the EEOC has said you are not allowed to make an employment decision on. The color of your skin, if you're disabled, if you're pregnant, if you're religiously observant, if you're an older worker, all these factors that have historically played an unlawful consideration in making a hiring decision, where that happens in the back of the person's mind. You never know whether a hiring manager has that bias, and if it's easy for them to say, well, I'm going to go with somebody else in their mind and saying, well, this person is disabled and it's going to cost me a lot more money. She's pregnant. They're going to need leave. And that's factored in. And of course, unlawful, and you can't do that. But that's the state of affairs of what we're doing now. There's so many studies across the board, whether it's in pay, hiring, promotions, that are similar to this. So that's sort of the issues we've been dealing with. And if AI is properly designed and carefully used, and we will get into that, it can actually eliminate bias at the earliest stages. In the resume example, there's AI software out there that will, look at the resumes in a fashion that masks all those protected characteristics, that actually uses the machine learning and artificial intelligence to go through and see what, the skills and characteristics that are on the resume, to then rank and make a decision for the employer without knowing if they're a male or female, without knowing their national origin and gender, et cetera. In the example I gave you with seeing the person, right? So there's a lot of interviews that are being done now completely the first round using AI, using your phone. So, you're answering questions on the phone that will then seek to determine how you answered the questions, the order you answered, and if that's to the employer's liking, to see if you have the skills. And you think about in both of those examples, these are people who have historically not been able to get to through the first level of the interviews because of those bias. And now you have all these individuals that are able to move forward based upon their qualification that never even got the shot, because the AI doesn't, if it's programmed accordingly, can't see those protected characteristics. So it can really actually help employers take a skills-based approach to hiring based on merit, which is where all employers, want to be and want to go, by removing a lot of these long-standing historical biases that we've seen in a very simple context. And no matter what the use of it, you can go through and say, yeah, here's how AI, like in these examples, can remove bias. But at the same time, if you flip everything I've said, if it's not carefully designed and not properly used, then the issue, and I think the fear of a lot of this, it can scale discrimination to the likes we've never seen before.
Yeah, I mean, a really good point, right? I think I am hearing this right. I mean, it's almost as though what has been biased for a very long time, and that's humans. And we have had a long history of seeing, biased human activity in connection with employment-related decisions. And so perhaps AI, while it has the potential for increasing issues at a scale, as you pointed out, could also end up being part of the solution here and trying to root out bias. So if I'm thinking about this right, I usually try to think about AI as like, all right, well, am I the developer or am I the user? The developer being the technology platform, the vendor who is, generating the technology, training the algorithms, deploying that for commercial use. And then you have the users who are licensing and purchasing those products and figuring out how to actually put them in the field. Two very different perspectives, and I think end up having maybe different responsibilities with respect to the technology itself. So maybe we'll just first start with the technology companies. I know you've been traveling around the country, meeting with many of the tech leaders out there and talking about these issues, and importantly, helping understand how is it that you can responsibly develop and innovate in this area while making sure that bias is being controlled for and is being identified along the way, and as much as possible, trying to root that out. Interested in your perspective on maybe first on the technology side of how you're working with those companies and your perspective about how they can address bias as part of the development process.
Well, I want to take a step back before I get into this because I think it's important to understand that in our world, in employment law, liability is a little different than other areas. And what's unique about employment law, because you're dealing with civil rights, is that whether or not you intend to discriminate, whether it's intentional discrimination, saying, I don't want to hire somebody because it's a woman, or, you have a neutral characteristic, your skill you're looking for, and it has the impact of screening out all female applicants, employers are going to be liable either way, whether it's intentional or unintentional. And the next wrinkle is related to artificial intelligence and these software vendors, is that we at the EEOC only have jurisdiction over the employer. And because under our laws in the United States, only the employer can make an employment decision for you, right? So the company you work for, the company you apply for, they're the only ones that can hire you, fire you, demote you, discriminate against you. So in that context, because that's where our jurisdiction comes from, where we only have jurisdiction over companies, employers, staffing agencies, and unions, because that's what the law says who makes employment decisions in the United States. So that is even a further wrinkle when it comes to artificial intelligence, because now the vendors who are creating the software, who are developing the technology, who largely, will have the data and the IP of the algorithm, are going to either be making employment decisions or assisting employment decisions. But at the end of the day, the company is going to be 100% liable if that algorithm makes a lawful or unlawful employment decision. And that's sort of where it is so tricky, and why I've been very proactive in trying to work with the vendors. And let me just go back to the examples I was giving you to explain the vendor side of this, because I said that my two key concepts of using it in employment is being that the algorithms are properly designed, which is obviously going to be on the tech side, the vendor side, and then carefully used internally. So, you talk about the examples I gave earlier about how it can eliminate bias. Well, let's just talk about how if the algorithm is not designed properly, then, how it's going to discriminate. So, we've seen a lot of examples of algorithmic discrimination. A lot of them come from the employment space. Some of the more well-known ones are, in these hiring cases where a company is seeking resumes for a certain position, and then the vast majority of applicants, just by nature of the job, historically were men. And there's cases there where the algorithms allegedly immediately gave females the lowest score possible. If you went to a women's college, if you played women's sports, any indication of being a female, you got the lowest score. And that necessarily wasn't a misogynistic intent on behalf of the algorithm. It was a function of the data that was fed to it in the first place. And that's the issue, because the algorithm in that case potentially wasn't sophisticated enough to say, well, we have 100 applicants, even though 95 of them are men. How do we go through and actually see what those underlying skills are, neutral of that protected characteristic, in this case, your gender? And for the company there, all the women automatically being excluded from that hiring process, they're going to be liable for that, even though they just wanted to find the best candidates. And that was the design of the algorithm. And then secondly, and that goes into a lot of the data set discrimination, which is common across all industries using algorithm, but also just shows the care and the need for the vendors to ensure that they're looking out, that their algorithm can account for excluding those protected characteristics that you're not allowed to make an employment decision on. But, also internally, you can have the most perfect algorithm that's only looking at skills, that's only looking at the factors necessary to be hired within that company. The algorithm goes through millions of applicants and gives you the absolute best candidates in a pool. And then, on the user side of it, if the vendor allows the user, and here think about like a hiring manager, to then be able to sort or use the algorithm to seek based upon those protected characteristics, these tools can be used to intentionally discriminate. You think about the amount of data now available that the algorithms can pick up on. So even if you don't have those protected characteristics on a resume, the algorithms are so sophisticated enough, they may be able to then sort that these are older workers, these are people from this country, or these are people who potentially may be religious observant because of the amount of data that they can pull. And then you just think you have a hiring manager internally that doesn't want to hire, let's say, again, easy example, I don't want to hire an older woman for this job, because that's just, again, you can't do that. But with a few clicks, the ability to use all that additional data and then remove all of those people can scale discrimination far greater than ever before. Because going back to the basics, there's a stat where it takes about 6.5 seconds for somebody to review a resume. And if you think how quickly these algorithms can do that, it's just much faster. And so that person has bias. It still takes time to discriminate. It takes more than 6.5 seconds. If you have to go through and say, okay, are they from this country? Are they from this background? I don't want to hire somebody from, who looks or sounds like that, versus an algorithm that can do it in a millisecond to hundreds of thousands of applicants. And that's sort of, where I've been trying to work with the vendors on both of those sides. We're saying, it's your algorithm that needs to be sophisticated enough to not have any of those protected characteristics or adjacent characteristics that are unnecessary to the job and skills at hand play any role in the algorithm determining, who to select. And again, you could use this across the board, whether it's promotions, whether it's pay. And then number two, what are you doing to ensure that the client, in this case, the company using it, is not going to then misuse it and use these tools to intentionally discriminate against how they're being designed and sold. So it's a two-part equation, but that's largely going to be on the vendor to be able to make those assurances and show, the companies using it, how they're going to comply with the civil rights laws, because at the end of the day, the buyers and then the deployers of these products are going to be liable for all of that, even though they aren't necessarily in the design side. And that's sort of the challenge of not being a technologist myself. And a lot of the people who are buying this also not necessarily understanding the algorithm. It's just a different language that everyone's speaking, but those civil rights protections are going to be there no matter what. And that's where really why I'm engaging in the vendor community and the tech community to ensure that these principles, because this world, a lot of people who are entrepreneurs who are really trying to help, workers get the best jobs and get out there and get in the workforce using these advanced AI tools. They don't want to develop products that are going to violate civil rights laws. It's just they need to be able to understand what those parameters are. And it's certainly been a challenge because for many people, this is the first time they're ever dealing with the complexities of federal civil rights laws.
Yeah, 100%. And that dynamic that you're describing is, that the tools and the technology is developed by one group and the users are going, and the deployers of that technology is a different group, but yet the deployers and the users are the ones who are liable in the event that the technology companies or the developers get it wrong. Like, that's a dynamic that I think creates a lot of concern, amongst employers and those who want to be forward thinking about the uses of these technologies in order to gain and harness the benefits that you were talking about a little bit earlier, but also ends up being some fear around whether they can, right? In other words, how in the world can a user of the technology that is, commercially available understand to what extent bias has been introduced in connection with the development process? How can they, identify, whether this particular tool is rooting out, some protected class of people, during the hiring process when they themselves don't get access to the development information, the underlying algorithms, the underlying code, understanding the training data that has gone into it. Interested in your perspective on how employers can try to balance those two things, being a responsible user of AI, but also not be in the position where any uses of the AI will automatically set them up for, potential liability.
And you raise a whole host of issues. And again, there's another issue here too, which is again, unique to our space, is that when you talk about this data, when you talk about the factors going to making into employment decisions that these algorithms are using, who owns the data there as well? Because a lot of the data, it goes to the vendors. The vendors make the decision and they give the employer the results. And for our context, when you're making an employment decision, you need to, especially in the hiring side, you need to keep all that employment data for that candidate or employee, for a year, because our statute of limitation for these employment claims is, generally 300 days. So employers have an obligation to hold those employment records for everyone who applied for a year, right? So, and on the outset, that's needs to, from an employment perspective, that's the company's data that they need, and they may never even have that but it goes out to a vendor. So, taking a step back, the issues here is, how do you understand if it's going to do what it's going to say it's going, being sold as? And I think there's a unique situation here where working with the right vendors, the companies can really push back, because a lot of the vendors, they will have done testing in the aggregate. They'll do disparate impact testing, which is where a lot of these issues are, based upon that sort of data set discrimination. And they will do it in the aggregate, and they will show in their sales pitch that saying, look, here's we've run this based upon the EEOC's standard for employment testing, and our product discriminates less than humans do. And look how, it works well. The issue with that is I commend them for doing that and getting out there and trying to, of course, get involved in the testing. But the problem is that it's so unique. Employment law is so unique. Every employee has different, their employer has different responsibilities for them, and there's just no one size fits all. So, when we do testing here, in an investigation or require it being done, it's literally on that one specific use of AI, that one job description in that one part of the country. And we're going to look, what is your data set related to that? That's going to be your local hiring pool of who's qualified. And then what, did you ask the algorithm to do? What skills, what requirements did you have the algorithm look? And what did that have a discriminatory result? And if it did, is there any potential justifications of why, based upon industry standards, based upon businesses, of why you needed to select those people? But my point is, it's done for each job description, for each employment advertisement. The testing needs to be done specifically at that level. So, when you're seeing some of these tests being done by the aggregate, it's just not going to mean anything when you're actually faced with using it. So my point is the diligence that's required, not just for buying this software, because it's sold as any other type of SaaS software, but it's different in our case because, not only you're dealing with civil rights, each use is going to have a different result. But the positive side is that there's a long-standing testing methods that the EEOC has had since 1978 to test if there's disparate impact in that employment decision. So you have the ability to work with the vendor on the front end to not only show how it will work with a job description, with a promotion within your organization, and to see if there's the bias or not right away. And I think what the benefit of artificial intelligence, unlike other kind of employment programs where you put out and you hope there's no discrimination later on, here we have the unique ability to test it before it ever makes a decision on someone's livelihood. So that's part one on the testing side, and we have a lot of guidance on that. But number two is then the example I gave before. What happens if you have bad actors within your organization? What happens if you have people down the line outside of law, outside of training, that have that EEO training? That will then misuse the systems, right? And this is no different than any other type of corporate governance or any other HR policy. And it's ensuring that, number one, the vendors are designing these programs to ensure that won't happen within your organization. And then number two, internally, if it does happen, what policies and procedures do you have to ensure that those employees are terminated who are misusing the system or disciplined? So a lot, as complicated as this gets, it still goes back to basics, where there's still a lot of, principles, whether it's on the governance side, whether it's on the auditing side, that have existed, since the 1960s and 70s. And that's where I've been trying to, in a sense, make this more boring, because at the end of the day, there's only a finite amount of employment decisions. And you're using AI to either make that decision or augment that decision or assist you with that decision. But at the end of the day, it's an employment decision, and your organization has principles related to how you hire, how you promote, how you pay, how you terminate. And we can't lose sight of that, because now vendors are coming in with advanced technology that you don't necessarily understand, promising to do that, and then not forego some of those longstanding principles on the testing governance side that already exists. So that's sort of where I don't want to say my conclusion in all of this is, but what employers can be doing now, because really for larger organizations, it's no longer a question, are you going to use AI within HR? I'm reframing the question to saying, well, you're going to have to use it to stay competitive because everyone else is, especially for large global workforces where you get millions of applications. You don't have millions of people to do all those interviews and conduct it. It's how are you going to use it? What purpose are you going to use it for? And more importantly, how are you going to ensure that it complies with these longstanding civil rights laws? And a lot of that happens in those front end conversations with the vendor, because the EEOC shows up. The company can't say, I don't know, go to the vendor. It's their algorithm. It's their technology. It just doesn't work. We're only going to be looking at the user.
Yeah, I mean, really interesting. Interested in your perspective on what enforcement has looked like in this space. Is this an area where the EEOC has taken enforcement action, or is this an area that's really just too early for that to have occurred yet?
Yeah. So this is the question everyone wants to know. And as you know, a lot of companies do some of the governance around enforcement, around seeing, what the results are of federal actions, of agency actions, or private class action litigation. And I think the frustrating part here for civil rights groups, for vendors, for companies who want to comply is, well, what has happened in court? What has happened with your investigations? And it's very hard for us to say, here's what happened, because we haven't seen these types of cases. And there's a main reason why we haven't seen these cases yet. And that's because like all other hiring practices, the company doesn't need to disclose essentially what they're doing behind the scenes. When it's challenged later on, for bias, then obviously there's investigations and you get into that. But, most employees do not know they're being subject to an algorithm. So when they have an interview, and then they get or apply for a job, submit a resume, and they get a rejection letter, they have no idea, if a human reviewed it and just weren't a fit, they weren't qualified, or if an algorithm unlawfully even gave them a chance because of it was discriminatory. And that's the biggest issue, because at the EEOC, we're charge driven. We are, and what that means is employees, once they feel they're discriminated against, whether direct evidence or not, they then file a charge of discrimination at the EEOC. And even if the employees knew they were being subject to, a facial recognition algorithm on a Zoom call that, disqualified them from moving further because the algorithm didn't like the way they were looking at the camera. And, there's alleged examples of this, which can lead to discrimination. You never know. And I think that's the trickiest part right now. So I think that the fact that there's not disclosure, there's not consent, makes it very difficult for us from a law enforcement perspective to prosecute these cases. And look, even if an employee did, they were being subject to an algorithm. When you come to the EEOC, there's not a box to check for algorithmic discrimination. It has to be based upon some other unlawful characteristic that the employee was subject to. So for instance, like an age discrimination case, no older workers are hired because of a discriminatory algorithm. That case would come into us as age discrimination. And then, with the, significant amount of cases we have, doing an investigation, we would then have to find out later that there was an algorithm involved, assuming that employee even knew. So you see, it's very complicated. And look, that's where I think a lot of states and foreign governments are recognizing that and are starting to potentially make those requirements of that consent, of that disclosure, that you're being subject to an algorithm, which will then change awareness of the consumers. And who are the consumers in the employment space? Applicants, current employees, former employees, aware of that they're being subject to this, and then essentially come forward and saying, now we know, and we believe it's the algorithm.
Right. So in other words, if you're thinking of like, well, maybe there hasn't been as much enforcement now, given the challenges around transparency and disclosure here, once the disclosure and transparency requirements come into more fulsome effect, then we're probably anticipating there will be more of these types of claims that will require the EEOC's investigation and kind of company interaction. I mean, is that where you see the policy kind of moving in this space? Because I think what you're describing right now has been largely the application of existing civil rights laws to this new technology. And I think that's probably consistent with how we're seeing AI be, regulated from a legal perspective across the board, as you're applying all of these old rules and these old standards against this new technology, which makes sense. But are you anticipating or kind of looking around corners that is going to be the dynamic going forward? Or are you seeing that there's going to be different ways of trying to address this from a policy perspective?
Well, this is where it gets complicated because, I'm in the executive branch here and we can only enforce the laws that, Congress has enacted for us to enforce. And that's why, again, when I got involved, I said, for the time being, until Congress creates a new AI agency or, gives the EEOC a lot more money to hire technologists, there's all these debates in Washington, D.C. We can't wait on that because this is being used right now. And it's being used to make employment decisions. And like I said earlier, at the end of the day, that's what's going to happen. There's going to be an employment decision to look at. And we know, our investigators know, to figure out if that employment decision had bias or not. So that's all we can do. Our laws may be old, but they're not outdated because they're applying to those employment decisions. I think you're seeing consistency with that at the FTC, at HUD, at other areas that deal with sort of civil rights protections and these technologies and housing finance credit advertisement, some of the higher risk uses of AI. All we can do is enforce these laws. Now, from a policy perspective, though, that's where I think you're going to see the changes occur of maybe not changing the fundamental of how you see if there's bias, but what are those additional requirements? And if you look at the states who are really taking the lead on this, or if you look at the EU, who obviously passed, the world's first comprehensive EU AI Act, they're starting to very much focus on AI in HR, again, because you're dealing with people's ability to enter into the workforce. So if you look about what's happening across the board there, you're starting to see a lot of common threads in those proposals that may have that, whether it's the Brussels effect, whether it's, California, the Sacramento effect, essentially nationalize some of these requirements. And the requirements are starting to get fairly similar. So even if you look at the EU AI Act, that consent, that disclosure, that auditing, that, the testing, and then in New York City, which had one of the first comprehensive AI laws, was related to AI, designating automated employment decision tools. And if you're using them in New York City, again, you have to do the bias audit, a pre-deployment audit. You have to do a yearly audit. You have to post the results of those audits. You have to give the candidate notice that they're being subject to these tools. So we're starting to see that across the board. But even, whether it's in the EU or New York City or what we've seen out of Colorado or proposals in California and other states, that forceful requirement to do an audit, again, how do you do an audit? And it comes back to us at the EEOC. So whether, you're in the EU or whether you're in New York City, how do you test for disparate impact in employment? That's the EEOC's 1978 Uniform Guidelines and Employment Selection Procedures. So a lot of that, to my point, is available now. And that's a decision companies are going to have to make, is saying, if we're being required to tell our applicants that we're using AI in the hiring process in New York, in Colorado, in California, in EU, at what point are we going to do it everywhere? And if we're required to do a pre-deployment bias audit testing or a yearly test based upon the EEOC's principles, well, I've argued you could be doing that, and the EEOC has put out guidance on that. You could be doing that no matter what. And if you're doing that proactively, you're just going to be in a much better position. Of course, working with the vendor to ensure, that they can help you with the audit and do the audit with your data. And if you see employment discrimination is occurring, you could change the metrics or not use the program and essentially prevent discrimination from ever occurring in the first place. And also give, the companies, again, who are going to face that liability, the certainty that they have a documented record of testing it before it goes live and ensuring that everything that you're asking the algorithm to do is putting the output related to your business needs and not discriminating. And that can just really prevent discrimination from occurring. We won't even get involved. And that's what companies can be doing now, absent being forced to do so. So I've been a huge fan of the self-governance side of this and doing those audits using our old laws and our old principles in advance.
Yeah, and maybe it's a fascinating kind of, dynamic, right, where we have these laws that have been passed, in the past now being applied into, artificial intelligence, really kind of pushing how the ways that artificial intelligence can start to develop to accommodate those existing principles in law. And where we're seeing that start to advance and develop, I mean, that self-governance model, I think, is really important, and one of the things that we're working with a lot of clients on to try to anticipate. But I think one challenge, and maybe this is where we can kind of end our conversation, is just around how does HR in particular kind of engage in this new dynamic? I mean, I think, without generalizing too much, I think this is probably for HR teams, maybe the first time that they're being asked to play a role as more of the technologist and getting into the details and doing these types of audits against technology, when in the past they have been other teams within an organization have been largely responsible for the procurement and the development and then the implementation, and HR teams are largely users. That dynamic, I think, has to shift. And I'm interested in your perspective on whether you've seen that go well, or if you have other tips about what organizations are doing.
Well, I think that a lot of this actually should start with HR, because HR is a very highly regulated space to begin with. You think about, when you start a job, how many handbooks and trainings and everything related to this. So HR is well equipped related to the rules of the road of how to deal with, employees, and having a lot of policies and procedures. And because AI is getting involved in this space, earlier, which is as some will say, I don't comment on risk that, riskier than other uses, because here, if the algorithm makes a mistake, people are going to lose their jobs. People are going to be paid less. People are not going to be enter in the workforce, which is far more problematic from both a outsider's perspective, from a publicity's perspective, and a legal perspective, than using AI to review documents faster, than using AI to make logistics routes, save a few cents here and there. So I believe it should start, within the HR department, but it's going to take that multidisciplinary teams and a lot of different stakeholders involved, from both obviously the IT perspective, from the legal and compliance perspective, but then the practitioner perspective. And that's where really HR leaders can take a lead within these groups and saying, like, here's exactly our processes and procedures, how we have done it, for a long time. Here's where we think AI can make that more beneficial or potentially remove bias, and then just go through all those different parameters of if the algorithms can actually do that. And again, that's working with the vendors, but having, the right teams both on the legal side saying, where does the data go? How are we going to be able to access it? How do we know that the factors that we are putting in there relevant to our industry, relevant to, this job, are actually the only ones going in the algorithm, and we're not looking at large language models that may inferring that this may be the best for this company, which you're going to be liable for, which may be baking other people's biases into that algorithm. So look, it's complex and it's a lot of work. And here's the biggest issue I see is that companies want to buy these programs to make these decisions more efficient. And you're spending a lot of money on the underlying infrastructure. In the HR space, it's even more complicated, because these are generally, the AI we're talking about generally are plugged into existing, human capital systems like Workday, Oracle, Salesforce, these big, underlying massive tech investments that these companies have already made. And now you're putting another layer into that. So just more expense on the tech side for that long-term efficiency and better hiring. And, where I'm just trying to slow that down is but to get there, there's a layer of governance that is necessary and required. And that's not going to be, that may not be as quick, as you may like, to do the testing, to build the policies, to ensure it's doing what it's supposed to be doing. But at the end of the day, you have to do that, because, the company, not the vendor, is going to be liable for whatever this does. And you can't point your finger at the vendor. So it's just taking an additional level of care and governance in this space. And it's a lot more work, but that's how we're going to get to the benefit of it without that significant scalability risk of civil rights violations.
Well, that is, I think, a really good practice point, and probably, I think advice that is probably well heeded. So I think, Commissioner, this has been a fascinating conversation. I always really enjoy kind of our interactions and learning more about kind of how you're thinking about these issues. So thank you again for joining for the podcast and helping all of our audience members understand how the EEOC is engaging on these issues.
Thanks for having me.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.